practice that was revealed recently, a practice involving employers coercing and compelling the disclosure of login information, usernames, and passwords to private accounts and private systems by job applicants. And the same kind of coercion and compulsion applied to current or existing employees as a condition of their continuing in their jobs. That kind of practice is abhorrent. And it is the reason that yesterday, along with a number of my colleagues from both this body and others from the House of Representatives, introduced the Password Protection Act of 2012. These practices are unacceptable for a number of reasons. An employer has plenty of ways, other than accessing private accounts, Gmail, storage data, and accounts on Facebook or other social networking sites, to obtain information that's relevant to employer needs and interests in offering a position to someone. There are other means that are adequate and acceptable. What's not acceptable is coercing and compelling that access to an applicant's email account, which could contain all kinds of personal information that is inappropriate and unnecessary for an employer to know. Information that is irrelevant, in fact, to the terms and duties of a person's employment. Second, the disclosure itself endangers the security of that applicant's personal data, as well as the websites themselves. Too many careless companies, too often, have lost customer data or employee information, allowing it to be breached through poor security practices. That is a reason that I've proposed a measure that would require safeguards of that data, a separate measure that is before this chamber now, to assure adequate remedies when there are breaches, to require systems in place by employers to guard that information. An applicant who takes care to use encrypted networks or other personal safeguards may find his or her personal information, financial data, medical information, breached through no fault of his own, simply because the company fails to take adequate steps to safeguard it. The Password Protection Act also very, very importantly prohibits retaliation, which is a danger with current employees. That retaliation can take all kinds of forms, but the demand for login information, usernames, or passwords certainly creates a kind of presumption that the refusal to do so prompts action that can be regarded as a retaliation. And an employer who violates these duties, legally required duties, is subject to a penalty of $10,000 per violation. It does not prevent an employer from controlling the company's own system, its own Facebook account, for example. And it provides that states may exempt certain categories of employees, such as individuals who deal with children who are under 13 years of age, or federal employees who may have access to classified or secure national security information. And it also provides for reasonable exemptions that state law may make for state employees who are involved, for example, in law enforcement or correction. Like many in this body, I've heard from countless Connecticut citizens who are not only offended but outraged by these practices reported in the press. Fortunately, many employers have shown they get it. They understand this deeply held value, and they have rejected these possible practices. And many who might have been contemplating engaging in them have likewise retreated and reversed their decisions. And so merely shining a light, showing a spotlight, and raising the issue has brought many employers to understand the common sense force of objections to these practices.